So friends, months ago, Special Counsel Jack Smith filed motions in Donald Trump's criminal case down in Florida. That's the one where he is indicted for unlawfully retaining classified documents, obstructing justice, and violating our nation's espionage laws. And Trump-appointed Judge Aileen Cannon has steadfastly refused to rule on many of those motions. But now, yesterday, Donald Trump's lawyers filed a motion demanding that Judge Cannon pause the case, put a stop to certain deadlines. And today, not 24 hours later, Judge Aileen Cannon rules and gives Donald Trump exactly what he wants. Friends, the fix is in. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, now that Donald Trump's Supreme Court has ruled, in substance, that presidents are kings, they are beyond the reach of our nation's criminal laws, Donald Trump thought he would take a flyer at, flexing his royal muscles. And he filed a motion demanding that Judge Aileen Cannon put a stop to some of the deadlines in his Florida case. And his court jester, Judge Cannon, performs for her king. Let's start with some of the new reporting. This from NBC News. Headline: Judge Aileen Cannon grants Trump's request to pause some deadlines in classified documents case amid immunity questions. And that article begins: U.S. District Judge Aileen Cannon on Saturday, friends, when court is usually closed, U.S. District Judge Aileen Cannon on Saturday granted former President Donald Trump's request for further briefing on the issue of presidential immunity in the Mar-a-Lago classified documents case and delayed certain deadlines. Cannon's order marks the latest fallout from the Supreme Court's presidential immunity decision on Monday, which ruled that Trump has immunity from prosecution for some conduct as president in the federal election interference case. That would be the president is king ruling, handed down by Donald Trump's imperial court. My editorial edition. In the order, Cannon afforded Special Counsel Jack Smith the right, but not the obligation, to file a submission on the use of classified information at trial. At the same time, she paused two upcoming deadlines for Trump and his co-defendants. Smith's brief is now due on July 18, and a reply from Trump's team is due on July 21st. The latest development comes after Trump's attorneys on Friday, yesterday, 1 day ago, on Friday, asked Cannon to pause court proceedings and consider how the Supreme Court's ruling affects the case. There is no trial date in sight in the classified documents case. That's right, friends, no trial date. Because Judge Aileen Cannon steadfastly refuses to set a trial date, even though Jack Smith has asked for one, and even though Donald Trump's own lawyers said they could try the case on August 12th. Judge Cannon said, nope, not setting any trial date. Why? Because the fix is in. And we're going to take on just one example of why we can conclude the fix is in just a minute. And then, with your kind indulgence, I'm going to take the career prosecutor's privilege and I'm going to read just a few very short lines from the new court filing yesterday by Donald Trump's lawyers. And I'm going to tell you what any self-respecting judge, what any judge who is an honest broker of the law, what any judge who cared about the ethics and integrity of the practice in her court, what that judge would do with the kind of court filing that Donald Trump's lawyers just submitted. But let's first talk about how we can tell the fix is in. Back in May, Special Counsel Jack Smith filed a motion with Judge Cannon asking her to modify Donald Trump's conditions of release in his criminal case in Florida, to impose a gag order, to impose a very limited restriction on his speech and his posts, to try to get him to stop lying and endangering law enforcement. Remember how he said law enforcement was coming to Florida to assassinate him and harm his family? And then we learned that Donald Trump and his lawyers knew that the DOJ and the FBI had coordinated with Trump's lawyers to make sure when they came to Florida, to Mar-a-Lago, to execute the search warrant, to search for the evidence of crime Donald Trump had at his home in Florida, they made sure that Donald Trump and his family members were not even in the state of Florida. But it didn't matter. Donald Trump lied about the circumstances and inspired some of his supporters to potential violence against the FBI. So Jack Smith filed a motion back in May saying, Judge, we need a limited gag order. We need you to modify the conditions of release so he will stop endangering the lives of law enforcement agents. Judge Cannon has yet to rule on that motion that was filed back in May. A narrow restriction on Donald Trump's speech designed to try to protect the safety of law enforcement. She won't even rule on it. But yesterday, Donald Trump's lawyers filed something demanding she, pause certain deadlines, basically, just grind the case to a halt. And in, I believe, less than 24 hours, she performs for her king. The fix is in, friends. Judge Cannon's impartiality might reasonably be questioned, which is the federal legal standard for her to be required to disqualify herself from the case, recuse. I will never stop talking about the federal law that governs Judge Cannon's removal from the case. For those of you scoring at home, I'll say it again, 28 United States Code, Section 455. If a federal judge's impartiality might reasonably be questioned, she shall disqualify herself. And we're still waiting for the motion to recuse, the motion to have her removed from the case. It will come at some point. It has to. But now, friends, let's turn to just a couple of things that Donald Trump's lawyers put in this court filing. And then we're going to talk about what any experienced, sort of thoughtful federal court judge would do if he or she saw this kind of garbage in a court pleading. In the case of the United States of America versus Donald Trump et al. And others, defendants, and this is captioned, Donald Trump's motion for supplemental briefing on presidential immunity and a partial stay. Donald Trump's lawyers include in this court filing stuff that, is ripped right from Donald Trump tweets. Things like, Jack Smith is waging a shameful, ongoing lawfare campaign. And Smith seeks to subvert the upcoming election. And this is election interference. But then I want to focus on just a few lines that are unlike anything I've ever seen in my 30 years as a federal prosecutor, in any court filing from a prosecutor, from a defense attorney. They say things like, President Biden's exceedingly weak debate performance on June 27. They say Biden's desperate and failing attempts to communicate with voters prior to the 2024 presidential election, and they reference what they call Trump's overwhelming debate victory. You know, friends, that kind of crap has no place in a court filing, has no relevance to any legal issue in the motion. And you know what any self-respecting judge would do if they were presiding over a case and a party, a prosecutor, a defense attorney, filed that kind of garbage in the public record? First, in my experience, the judge would consider striking that language from the motion, striking it from the record. And then the judge would likely consider setting what's called a show cause hearing, directing the defense attorney who authored that crap to show cause, to convince the court that he should not be sanctioned for that unprofessional and potentially unethical conduct. That's what a judge who cared about, the ethics and the honor and the practice of lawyering in federal court or in any court would do. You think we'll hear a peep at a Judge Cannon about the garbage Donald Trump's attorneys put in this court filing? Because what they did was language like that is their attempt to convert a court filing into a campaign ad. That is not the way the criminal justice system or motions practice is supposed to work. Because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.